All right, everybody. Really appreciate you joining us today for our July NAA webinar. We've got a really cool speaker. My name is Charlie Culpepper, by the way. I'm the Director of Membership and Public Outreach for NAA. But before we kick it off, just a little housekeeping. We're going to keep everybody on mute during the presentation. You can use the chat function anytime to drop questions into, and we'll facilitate those after the fact. Robert's going to speak for probably about 30, 35 minutes, and then we'll open it up for Q&A with the audience. And I think this is a really unique presentation today. I really appreciate Robert doing this for us. And yeah, I expect to have some pretty interesting Q&A as well from everyone. So with that, let me introduce Robert Smith. He's our speaker this month. Robert's a partner at K&L Gates. K&L Gates is a global law firm with over 20 offices throughout the United States. Robert's a member of the firm's environmental, land, and natural resources practice group. His practice focuses on land use, government and regulatory permitting, shoreline development, and aquaculture. He's assisted dozens of aquaculture companies in obtaining local, state, and federal permits and licenses, lobbied on behalf of the aquaculture industry for legislative, regulatory, and policy initiatives, and defended aquaculture companies in litigation and enforcement actions brought by private parties and regulatory agencies. He currently splits his time between Seattle, Washington, and California, and spends a lot of free time in the mountains, hiking, camping, and skiing. So with that, Robert, I'm going to turn it over to you. You've got your screen share on already, so really look forward to your presentation.
Great. Thanks, Charlie. And good afternoon, good morning, wherever you guys may be. Thank you for having me today. Today is part one of a two-part series I'm proposing to do with NAA, which walks through strategic considerations in navigating opposition during the permitting process. So today I'll focus on preparing for the permitting process and navigating those issues as you go and interact with regulatory agencies as well as potential opponents during the permitting process. Part two, which will be held at a later date, is going to address if you ever get involved in litigation coming out of the permitting process, whether that be litigating on your own behalf, challenging a denial of a permit or onerous conditions, or seeking to defend a permit based on a challenge by a project opponent. So first, let me see if I can get this going here. There we go. First, I want to back up and talk about really what are the goals of a successful project. The first one is obvious, and it's one that hopefully everybody's thinking about, which is get the project approved. But there are several other goals you need to be thinking about as you navigate a permit process successfully. It's not just get the project approved, but make sure it's with workable conditions, within a workable time frame, that avoids litigation or maximizes the chances of successful litigation, and at a reasonable cost. And when I talk about the permitting process, really, I hope that you can think about the permitting process holistically. And it's not just the permit itself, but you also need to be thinking about things like site selection, outreach and messaging, obviously the permitting process itself, setting yourself up for potential successful litigation, and then also dealing with compliance and enforcement issues once you actually have your permit in place. And this whole process, if it's your second or third permit, this process in your first permit or second permit will continue to reinforce itself as you go through the permitting process in subsequent times. So I think one of the most important considerations when going through the permitting process is really before you submit a permit application whatsoever, and that's in site selection. Site selection can be critical in trying to avoid environmental issues, trying to reduce project opposition, and try to make things smoother as you try to coordinate with appropriate regulators. So really, I think the goal when it comes to site selection for an aquaculture site is maximizing productivity and efficiency while minimizing opposition and regulatory hurdles. Obviously, as aquaculture farmers, you think about those first two things all the time, trying to maximize the efficiency of your farm, the productivity of your farm, making sure that your farm is set up logistically and operationally for success. But I would say that those other two things are also vitally important. Most studies show today that in terms of barriers to aquaculture expansion or entry of new companies into the aquaculture industry, the permitting process is the number one hurdle most frequently cited for that's holding back expansion of the industry. And I think that trying to focus on appropriate site selection to minimize opposition and regulatory hurdles can really help in reducing cost and time frame necessary to navigate the permitting process. So how do you go about careful site selection? First, seek out favorable jurisdictions. That means that as you're looking at the geography for where you may install a farm, seek out ones that have experience in the aquaculture industry and aquaculture permitting. Inevitably, it's almost always easier to deal with a regulatory agency that has addressed the aquaculture industry before, has done permitting before, as opposed to one where you're the first in line in the first aquaculture permit for a particular jurisdiction. That becomes very, very difficult to navigate if you're the first ones to actually have an aquaculture permit within a particular county or a particular city. Also, think about which ones are supportive of aquaculture as opposed to which ones may have a oppositional view to aquaculture projects. Not just in terms of the politics of a jurisdiction, but also think about what the local and state permitting process looks like. So for example, I'm out here in Washington State, one county in particular that has a strong, favorable outlook for aquaculture and a relatively easy permitting process. We can navigate that and get a new aquaculture permit in approximately about 4 months. If you go 2 counties northeast of that county, where they don't have a great outlook on aquaculture, they've had a huge amount of staff turnover, so they don't have the resources to process their applications, and they have a much more extensive permitting process with multiple public hearings. If you're looking to site a new farm there, I'm saying to those applicants, it's going to take 2 years. Obviously, there's a huge amount of impacts to your potential farm if you're trying to navigate a 2-year process instead of a 4-month process. So it's really important to understand how those local permitting processes and state processes may influence your overall application process. Also, minimize potential sources of opposition. And so there's a variety of potential opponents to aquaculture farms, and trying to utilize smart site selection before you even submit an application can go a long way in reducing those potential sources of opposition. So for example, try to identify important habitats or habitats that are important for specific species in locating your site to minimize potential opposition from environmental NGOs. So for example, on the West Coast, you want to avoid things like eelgrass or a hard bottom habitat that's subject to the core jurisdiction, which are special habitats that have special regulatory protocols and are particularly controversial if you want to site things in those areas. And so those are all things you want to consider what's important to your project regionally to see if you can reduce or eliminate overlap with those special habitats. Also, are there tribal interests? In some states, there's very robust tribal treaty requirements in terms of coordination with tribes, making sure that tribal treaty interests are not impacted. And both state and federal agencies have requirements in most states to consult with tribes. And so you want to make sure that you understand the tribal interests in your area and whether or not there's any tribal interests that need to be minimized or respected in a way to not interfere with their existing resources. A big one is also user conflicts. Are you in an area that has a significant residential shoreline presence that may have a set of considerations? Are there shipping lines or vessels or ferry traffic in your area that you need to avoid those transit lines? Is there a significant recreational or commercial fishing presence in the community that you need to consider? The appropriate site selection early in the process can go a long ways in trying to minimize those user conflicts and set your application up for success. And finally, show your work. So a lot of this work you do every single time that you look to locate a new farm. But importantly, the local, state, and federal agencies usually need to go through the same sort of analysis. So for example, in the National Environmental Policy Act, you have to go through an alternatives analysis to evaluate various alternatives in addition to your preferred site. So if you've already done a lot of that work, make sure that you can show that what you've done why you have reduced or eliminated certain sites due to feasibility concerns or other concerns, and what the work you've already done in submitting your application. That makes it a lot easier for those other agencies to basically take your work and incorporate it into their processes. So there's a second point that's important beyond just simply site selection is being proactive. And I think there's a variety of ways you can be proactive during your application process. One of the most important ones is early outreach. 20 years ago, I think it was a lot easier for some projects to say fly under the radar, maybe hope that they're not going to get a lot of attention from the community or potential opponents. Those days more or less today are gone. With the advent of social media, the more national focus and interconnectedness of aquaculture opponents, I think it's very difficult to say fly under the radar these days and expect that your project is not going to receive some sort of attention. And so early in the process, try to minimize opposition to the extent you can and develop your allies. So meet with opponents early on, at least ones that might be reasonable. See what their concerns are, see if they can be reduced even before you get to a public comment period. Also develop your allies. So, one thing that we see a lot is when you have an environmental NGO on one side that opposes the project, we'll get questions, well, can we get a public comment letter from an environmental NGO that supports the project? And certainly there's some out there that do support aquaculture, but what they don't like is sort of be brought in as the white horse at the 11th hour. If you want to get their support, their participation, it's absolutely vital that you engage early in the process and make sure that you're developing a project that they could actually get behind and support. Finally, don't say anything you would like to see printed in the paper or on Facebook. That's obviously something that can be very, very frustrating as you go through a process, either with regulators or with comments that are made during the public comment process. And inevitably, it's much to your benefit if you're seen as being the reasonable voice in the room. To the extent you can, avoid personal attacks on project opponents, avoid a tit for tat. Usually that doesn't go very well. Certainly you can voice those things in private, but make sure that they avoid being repeated in public. So again, on early outreach, be proactive. And this next point I think is really important. Listen to the community. Listen to people that you engage with, whether they be environmental groups, regulators, people in the community, residents, etc. I think everyone in this industry does a great job of telling their story, of telling why their project is good, why it contributes to the local economy, why it's a productive food source, why it's good for the environment, etc. And that's a critical part to getting your applications approved. But just as important is being an active listener. Instead of just doing the sales pitch, make sure you're listening to the community, make sure you're understanding what their concerns may be, and be willing to adjust to address reasonable concerns. 9 times out of 10, the projects that I work on, the project that's proposed at the very beginning is not exactly the project that is ultimately approved, at least for controversial projects. And so be willing to be flexible to an extent that still makes your project economically feasible, that makes it logistically feasible, but can still adjust to accommodate sort of reasonable conditions or mitigation measures. And so, that's an important part as well, in terms of identifying ways you might be able to adjust it. Are there ways that you can incorporate mitigation measures or conditions of approval that are either recommended by stakeholders or by regulators that both makes your project more legally defensible, but also can serve as a tool to reduce opposition? And the final point here is, I think that site visits are critical to the extent you already have farms in operation. Getting regulators and stakeholders out to see your farm in practice, I think is invaluable. I think that a picture is 1,000 words, and experience is even more than that. Certainly when you're trying to combat misinformation that might be out there from project opponents, it's incredibly helpful to, especially even before you start your permitting process, if members of the community or regulators have actually been on an active farm and see how it actually operates. Usually that can be a really solid defense to some of the misinformation that may come out during the permitting process itself. And if you don't have an active farm, certainly if you have somebody in the community that does, and they're willing to sort of help out to say, or sort of see what a farm looks like in practice, that could also be really helpful. Part of that sort of early engagement is identifying critical issues. And so part of that in the stakeholder engagement process, where you're trying to not only get that social license and support for your project, but also really understand the key areas of concern. So early engagement with regulators, even before or right after you've submitted your permit application, and members of the community will help to hone in on the areas that maybe need to be addressed by your project. So you should be talking to other farms that have gone through the process within your regional area. Talk to regulators about potential things that they have encountered on previous application, and certainly understand the concerns of the community. And then early on, develop a strategy on how to address those concerns, and particularly be proactive, address those concerns in the application materials up front. The reason why that's really important is that it helps you to design that narrative. It helps you to frame sort of that story about how those things are going to be addressed early on the process, as opposed to waiting for public comment to come in on issues that are going to come up. And that also sort of signals to regulators that you understand the issues, you've thought about the issues, and you're being sophisticated and addressing those issues to the extent they can be addressed. So it can really set up your application materials for success at the forefront. So not just to be proactive before you submit an application, but also be proactive in your engagement when it comes to the permitting process itself. So first off, I'd recommend to submit a fully baked application. So I've run into some companies and applicants before that said, well, I really want to start the ball rolling. Let's just get an application in the door, and then they'll come back with some comments, and we'll work from there as an iterative process. I'd recommend against that. Your application is your first opportunity to make a good first impression, not just for the regulators, but also for the public at large. It's their first, in many cases, their first understanding, at least to the public at large, that this application and this farm is being proposed. And so in most cases, you want to try to make that first impression as informative as possible and as thoroughly thought out as possible. And so try to have as much information and have a completed application as possible when you submit it to the regulatory agencies. No offense to any regulators on the phone, but do not rely exclusively upon regulators regarding the permitting process. Certainly regulators can be an excellent source for information, and you will have to work hand in hand with those regulators to navigate the permitting process. But then again, their word is not always gospel. There are other interpretations of their regulations. There's some, especially for unique projects that they haven't experienced before. There may be other ways to navigate the permitting process, or information needs or mitigation measures, etc. And so don't rely upon them exclusively to come up with the answers. Make sure that you have a healthy source of skepticism and are doing your own independent review of those requirements, those permitting processes, etc., to confirm sort of what you're hearing from regulators. And if you don't agree with what regulators are saying, respectfully, advise them and engage in discussion early on the process for maybe how you can resolve those differences. Next, permit sequencing matters. So for most marine projects, you're going to have a whole suite of regulatory approvals, consultations, and permits that you need. That can be anywhere between 10 and 30 permits and approvals and consultations, depending on where your farm is located. And so understanding how all of those review processes work in sequence is really important to developing an efficient permitting process. And so a lot of those permitting processes can overlap, although the end of those processes need to happen in a certain sequence. So a good example, the Coastal Act certification, the Coastal Zone Management Act, needs to be done by the state or local entity before the Army Corps can finalize their permit. But those two processes can happen concurrently throughout the entire process. So making sure that you can set things up to be as concurrent as possible instead of sort of lockstep in sequence is going to be really helpful to try to shorten that permitting timeline. Also, develop your team early in the permitting process. So this is my shameless plug that it's often good to involve a lawyer during that early in that permitting process. There's certainly been times where I've been engaged either after the permitting process is done and it's already subject to an appeal or litigation, or when they've already encountered significant opposition and they've unfortunately made some statements in the record that we wish they had not. And so it's important, I think, especially for a controversial project, to try to get some legal counsel early on the process. That certainly makes the job of any attorneys easier, especially when it comes to supporting the administrative record, which I'll talk about in a little bit. Also, that's important to engage, environmental consultants, engineering consultants as needed early in the process, so you can inform those processes and then help engage with the regulatory agencies and make sure that your project is both set up for success at the permitting level, but also defensible in litigation. Next, know your deadlines. So there's a variety of deadlines that come up in the permitting process. Know your deadlines for your own responses and make sure you're making timely responses. Make sure you know the deadlines for public comment and be ready to respond to those after the deadline is passed. And also be aware of agency deadlines. There could be a variety of deadlines both for local, state, and federal processes for when things need to be processed. So for example, new NEPA requirements require an EIS to be prepared in 2 years. There's also requirements for agency consultation in the Clean Water Act that requires certain responses to be done by then. Certainly there are local deadlines as well. Make sure you're aware of those and holding those agencies to those deadlines where it's appropriate to do so. One more just note for those of you that are involved with any Army Corps permitting, be engaged actively in consultation with the resource agencies, NIMS and U.S. Fish and Wildlife. Sometimes the Corps doesn't particularly like that. They like to sort of be the gatekeeper, but I've found that direct consultation and engagement with those while also involving the Corps has been really helpful. Next, hopefully you've gone through early engagement. You're already sort of actively involved in the permitting process, but importantly, know your opposition. And so I think it's important to know who your opposition is, what are their goals, and what's the possibility of them sort of taking this to litigation or some other adversarial proceeding. So there's going to be some opponents that quite simply just don't want aquaculture, don't want an aquaculture farm in that area. And, for those folks, you're not really going to be able to do much in terms of reducing their opposition or swaying their opinion. But there may be others that certainly want some changes to the project, want some reasonable conditions, and to the extent that you can engage with those groups, understand their concerns, and try to accommodate them in a reasonable manner. You want to identify those and hopefully change those from opposition to support. And then third, understand your litigation risk. Is this a group that litigates frequently? Are they funded enough to do litigation? Are they taking that posture during this process? Because that will certainly inform the extent that you interact with that group, but also your response to that group during the permitting process. The next really critical point, I think, is to create and defend your administrative record. In most cases, if there is litigation on a permitting process, that litigation will be tied to what the administrative record was, what the evidence was before the agency that made the decision. So in other words, unlike some other types of litigation, you can't usually supplement the record after that agency decision because the court will focus on what the agency had in front of them at the time. So make sure that you're telling your story during the permitting process, providing evidence, providing analysis where needed in order to really strengthen that administrative record and make it litigation ready or support what the regulatory agency is looking at before their approval. So use environmental experts where needed to fill in information gaps. Certainly engage in the environmental review when it comes to NEPA and the state environmental review. Don't simply rely on the regulatory agencies to prepare that, because you are the best to know your farm, your logistics, your operations. And so providing that technical level of detail, that logistical and operational detail can be really important during that process. And provide responses to comments. Even if the agencies are doing that as well, make sure that you get all the comments and provide responses to them. So that's part of the administrative record. And finally, game plan for public hearings. It is likely your best opportunity to influence both regulators and respond to the public in terms of a project. And so make sure you know exactly who's going to testify, prepare your talking points accordingly, and make sure that you have a game plan going into that for your sort of your line of attack when it comes to getting the project approved. Also, make sure that you know how long you get to present on a project, because that varies from agency to agency and locality to locality. So lastly, what if regulators are opposed to your project? A couple of things on this. First, make sure that you escalate those concerns from low to high within a regulatory agency. While you might know the director of the agency, you might know the mayor or the city council person. Usually they don't appreciate it if you go straight to them without sort of working through the hierarchy, and certainly staff won't appreciate that. So start low and go high if your issues are unresolved, but try to go up through the bureaucracy as it's been laid out. And litigation, process challenges win more than substantive ones. So make sure you pay attention to see if they're following their own protocols and processes, and identify any procedural errors, because those are easier to win if you do need to litigate an issue. And again, make sure it's to protect your administrative record. One of the things that I see, which is really unfortunate, is applicants that will rely upon the agency, staff is in support, it's all been great, it's all been kumbaya until you get to the public hearing. And then for bowing to political pressure, the regulatory agency disapproves the project. If you haven't been proactive in supporting your own information, providing your own information, the administrative record, an applicant can be caught unawares and without a great administrative record to support the project and potential litigation. And the last thing I'll just say here is that make sure you evaluate whether or not there's a potential taking. 10 years ago, I got this question a lot when a permit was denied. They say, "Is there a taking?" And my answer, 9 times out of 10 would have been no. But the Supreme Court in the last 5 to 10 years has shown more of a willingness to expand the scope of what's considered a regulatory taking, both in terms of onerous conditions that are imposed on the project, as well as denying the reasonable use of property. And so it's a question that now I think is worth asking in certain circumstances. And so if you are in a place where you're facing a permit denial, it's at least worth a question asking your local counsel or your attorney representing you on the project whether or not there's a potential argument there. So thank you for letting me speak today. Thank you to the NAA and Charlie for putting this together. And now I'm available to answer any questions.
All right, thanks, Robert. That was great. Bob's got his hand up already. Yeah, I really appreciate that thorough presentation. As a former state regulator, I administrated a state leasing program as well for aquaculture, and I would completely agree. The critical importance of site selection and doing your homework up front. Not only can it get you through a permitting process initially, but years down the road, you can avoid hurdles as well. So it's just very wise information, and it's just great to have you. And with that, Bob, I'm going to let unmute. Fire away.
Robert, good to see you. Want to point out to those on the call here that you've been very helpful to our industry for many years now, useful at the ISSC, useful in litigation, and we appreciate your efforts on our behalf. So I just want to point out a couple things that we've run into lately here on the East Coast. And that is that proactive reaching out to the abutters, as it were, has occasionally backfired dramatically. And when you think you're doing the right thing in terms of alerting them and telling people what you want to do, you find out that they immediately form an association and start to hire counsel and block your application before they've even gotten a full explanation of what you want to do. We also have several communities have got lawyers running around saying, "We will help you, your homeowners association, block aquaculture in your neighborhood," hanging their shingle out and advertising their services to block aquaculture before the application is even filed. So I just was curious if you had any advice in those kinds of situations.
Yeah, I mean, I think and Bob, thanks for the comments. I mean, that certainly runs the risk, right? I just think that in most circumstances, uh, those people will be aware of a project once an application is filed in most circumstances, and those sort of rabble-rousing attorneys that might be on the other side are certainly out there trying to scan for any aquaculture applications that may be filed with local agencies. And so, I think that that sort of unfortunate involvement is in most circumstances inevitable. Now, or that early outreach certainly can backfire by allowing that group to coalesce earlier than they would if it was upon sort of the submission of the application. But it also has worked in some communities to be successful. There's a variety of circumstances and instances where it has been successful to reach out before misinformation is out there, because once some of the anti-aquaculture groups learn about new application in the process, then they'll come out with a whole host of misinformation and arguments against it. And to the extent you've already reached out to neighbors, reached out to others to sort of establish that you want to be part of the local community and inform them about that, that can be successful. But it does carry a risk in some areas that your coalescing group maybe earlier than they would. I think that's why it's particularly important. I mean, obviously this is a national call, but to know your community, know your region. There are some areas that we work with in Washington, for example, that we know are hotbeds for anti-aquaculture activity. We know that that early outreach is not going to do much because of the particular region or water body that the farm is to be located in. And those areas, we do tend to advise a little bit of a different strategy. So it really depends on the region and locality. But the more you know about the community, the easier it'll be to sort of identify the appropriate process for there.
Very helpful. Thank you, Robert. Just one last comment, and that is, well, you may not want to hear this because it's a free mediation process that's offered by the USDA in almost every state in the country. And it has been fruitful in a number of applicants in my state in resolving what appeared to be unresolvable conflicts. So just throwing it out there that free mediation services are available through the USDA in almost every state for farm-related activities, which we are. Thank you very much, Robert. This has been good. Look forward to your next one as well.
Thanks, Bob.
All right, Sebastian, let you unmute.
Yeah, thank you. And Bob, good to see you again. And I will just start by saying that I wish that every lease applicant in the United States of America saw your presentation and adhered to your guidance. I think it would collectively save us all a lot of pain. I have a couple of questions. One is, and I also want to support what Bob Rowe just said, which is that there are instances where trying to do the right thing does backfire on you. We've had a couple of instances like that in Maine, and that can be very frustrating for applicants. But I agree with you, Bob, that I think that's probably going to happen inevitably anyway. The question I have for you is, we have had some instances in Maine where the opponents, I'll give you two specific examples without naming companies. In the one case, the opponents to a particular lease application started to spread some completely false information that almost was slander around an applicant and an applicant personally and their company. And the applicant was really struggling with, does this cross the threshold whereby even though I am in a permitting application situation, I need to go legal on this because of my personal reputation. And that I know, I understand that that's probably an issue between the applicant and their legal counsel, but just interested in your kind of thoughts in general on that. And then the second example, so we actually had and I was not familiar with this term until this came up, but we had an instance where a paid consultant for an opponent began to target the product that was being proposed to be grown on the farm to the point where, and it was the applicant who brought this term up to me, and I wasn't familiar with it, but apparently there is a term in the legal profession called demarketing, where you are actually a priori hurting somebody's market before they've either been in that market, or if they have been in that market, you are damaging their ability to sell to that market. And so that's a different kind of damage, if you will. And I'm just interested in your thoughts on either one of those cases. And I realize that, you know, each one is very specific to the specific instance, but in general, is that stuff that you have dealt with in the past? And what are your thoughts on it?
Yeah, sure. So on the first one, I would say, and that's a question that comes up a lot, especially in really contentious, controversial projects, because there's members of the public often aren't held to the same standard as the applicant or the regulators in terms of what they say. And that can be incredibly frustrating for an applicant, especially one that's dealing with, you know, misinformation, personal attacks. It can get really nasty. I've certainly been involved in some of those before. Unfortunately, particularly when it comes to permitting processes, the bar for defamation and slander is usually significantly high. That doesn't mean it can't be breached. It's a state law concept, and so it really varies from state to state. But in most cases, it's a very high bar to prove that somebody has defamed you or slandered you, at least in the permitting process. You have to, in most states, prove not just that they lied, but that there's some economic damage to you, and you know that they knew that they lied. And it's a very difficult standard to make within a permitting process. Also, some states have what are called anti-SLAPP statutes that also sort of lay on top of that, that protect free speech in the permitting process, and actually can create liability on a regulator or an entity that tries to quell that free speech. For example, California has one like that. And so you just have to be very careful before you initiate, you know, any sort of legal proceedings, as frustrating as that can be on that question. So certainly that's something that you would want to sort of discuss with, you know, an attorney that's experienced under defamation statutes within the state law itself. But I had a recent case that dealt with that, where we unfortunately were not able to bring a defamation case because we thought that it wouldn't be successful in court, despite the fact that there was some very incendiary language being used during the permitting process by a particular opponent. On the second issue, you know, I think that's one of those that I think, as you noticed, Sebastian, is so facts driven that it's difficult to sort of opine sort of generally on it. I haven't seen that being used as a successful legal argument, at least in the cases that I've dealt with. It has been mentioned, you know, once or twice, but again, that is it's really, you're sort of dealing with the economics and the particular species there, and that's really a sort of it's tough to, you know, it's such a factor-driven process on that one. It's difficult to sort of provide some general guidance.
So a follow-up question, Robert, from Bob is, how often are you seeing an applicant sued instead of the permitting authority?
So I would say about 80 to 90% of the time, they're going to be suing the permitting authority, because in most statutes, including at least including the local and state ones, because the permitting authority is the one that is issuing the permit, they're the ones that are going to be subject to the litigation. Now, obviously, in almost every circumstance, the applicant will come in as a real party of interest to preserve their own rights and legal rights and arguments in the case or the administrative proceeding. There are some, I think, more rare circumstances where you get a lawsuit directly to the proposed applicant. That's in a case where you're getting to something that's necessarily that's outside the permitting process. So that could be either operationally that they're concerned about an actual harm that is going to be done by the permit itself, like something like a tort. Again, most of those are very difficult to prove because those tend to be pretty speculative. But the more common ones also deal with real estate issues. And so in a lot of states, tidelands are very difficult to survey and certainly more difficult than upland properties. And so the most common time where I see a lawsuit directly against a shellfish company or an aquaculture company is where you've got a real estate boundary issue where somebody is arguing that there's been a trespass or you're not appropriately the owner or lessee of the property.
Okay. So feel free, anybody else jump in. We've got plenty of time left with Robert. Robert, in the meantime, I was going to just ask, we talk about identifying stakeholder groups or opposition groups ahead of time in site selection. What are the most common in your experience working with the aquaculture applicants? What are the most common stakeholder groups that you see come out, in opposition? And then to follow up, how do you recommend folks identify those groups in like the local area and kind of reach out to them?
Yeah, Charlie, that's a great question. And I think that it really depends on the region. And so I'll get, for example, even within a national environmental group, you may not have the same response to an aquaculture project depending on the region to region. So for example, the Audubon Society as a national group takes a relatively I would say a modestly adversarial position to aquaculture, but they don't tend to get involved in a lot of litigation. The San Francisco chapter or the California chapter of the Audubon Society has taken an extremely aggressive view against aquaculture. But then you go to the local chapters, the ones that are in Humboldt and Tamales Bay in California, and they are at least neutral, if not somewhat supportive for aquaculture. And so it's important to know, even at national environmental organizations, who you're dealing with and who's sort of speaking for that organization and what is the position of theirs on a regional level. Certainly, like Bob mentioned, there are, I think, unfortunately, more regional groups that have coalesced against aquaculture. And so from region to region, you may get some that are going out there and getting a neighborhood group, getting NIMBYs coalesced to oppose something that particularly that may be near a residential area. And I think you've got the ones on a national level that you see as sort of frequent players. And so that's the Center for Food Safety has been a frequent litigant nationally, not just for individual projects, but also for national, say, nationwide permits that may be in play. And we anticipate that their opposition will continue in a marine context, especially for offshore. Oceana is one that's raised some concerns, but honestly, they're one of the ones that actually tends to be a little bit more reasonable and trying to permit it sustainably as opposed to being completely opposed to it. And so I think that a way to evaluate that on a local level is to sort of see what's happened before, take a look at, talk to regulators, see if there's other applications that have gone through the process in the area, get the comment letters on those, see what happened there. And that will help you to evaluate which ones are reasonable opponents you might be able to engage with and ones that quite simply you're not going to be able to convince one way or the other. The only other thing that I'll mention, because Sebastian and Bob both mentioned this, and I not going to part two of the part which will be on litigation, but I think that one of the important things to think about, and certainly comes up in mediation, is know your goals for litigation before you enter it. I don't know how many times at the beginning of every single litigation matter that I deal with, we talk about that. I say, listen, you might be right, but it might also cost you $200,000 in time to prove you're right. Is there a $20,000 fix here that, as opposed to just being right about this, maybe we could get away with 10% of the overall cost. That's something you want to think about. Obviously, not. You've got some people that say, well, no, I want to set this precedent because it's going to be very good for other projects. So that $200,000 is money well spent into the future. But mediation is one of those helpful things, particularly one that goes through USDA, that can be a cost-effective option as opposed to sort of going through a full-blown litigation process.
All right. All right, Sebastian.
Yeah, well, first of all, Robert, kudos to you for being a lawyer who just said what you just said. It's not every lawyer that would say that, and you deserve even more of my respect because of that. This is a crazy question, but I got asked it the other day, and I honestly didn't know how to respond to it. Some of our colleagues in other countries have had some success in going after the tax status of their opponents. And in particular, in the EU and in Canada, some of the very large environmental groups are classified as charities, nonprofit charities, which is a little bit different than our 501c3s, but there are some similarities there. And I guess the question I have for you is, to your knowledge, has anybody, if somebody's really opposing something, has anybody gone after the tax status of the groups that are opposing these in terms of their nonprofit status?
That's interesting. To my knowledge, I can't think of a case where that's been litigated. I know that issues come up, from time to time in arguing that point. On tax status, both at a state and a federal level. But I don't think that anybody sort of pressed that claim through litigation to its sort of end conclusion. And I would say that courts, particularly on the West Coast and in the Northeast, but generally in other places as well, tend to be very protective of environmental groups and sort of what they prefer as their overall goals and objectives. The one area where this gets frequently litigated has been in standing questions where they'll say this environmental group really doesn't have an interest or doesn't have the interest of their members in advocating for this litigation. And that's met with mixed results. But I would say that most of the time the courts have been protective and deferential to what the environmental NGOs or aquaculture, anti-aquaculture groups are saying in terms of their preferred goals and objectives. They'll say, well, I kayak here, or I really care about that bird or that otter or whatever. And that tends to hold the day when it comes to those standing issues. And so I would imagine it'd be difficult, given that sort of precedent, to make a similar claim on tax status. But that's interesting. I haven't seen that brought up in terms of actual litigation.
Yeah. Okay. Thank you. I mean, that's what I kind of figured, but I was intrigued when some of our colleagues in other countries took that tack, and at least in the case of the UK, it was actually successful, and sent a very strong message to the NGO community about who they were dealing with and what they should or shouldn't go after from a opposition and campaigning point of view. It was a pretty interesting set of circumstances, I think.
The one interesting thing there I've got other partners at the firm that deal with tax and tax litigation, far more frequently than I do. So I'm sure they may have some thoughts on this. But the one interesting tack that I think is at least, worth a thought is that a lot of these groups are using litigation as a funding source for their own operations. They'll go out and say, we're going to sue X, go give us money so we can sue X. And the more information you could get on that, especially if you're in litigation and doing discovery, to understand where their funding is coming from and whether or not that funding is just coming through just to litigate a matter as opposed to the broader environmental goals of the organization? I think that's at least an interesting question that, might provide some grounds for the type of complaint you're talking about.
All right, Bob, I just unmuted you.
So Robert, I've got a question for you. Very often in public hearings, I'm faced with someone who's patently willing to stand up and tell bald-faced lies. And, we boat there every day. I make a living digging clams there. I've had this happen innumerable times in innumerable hearings. Is there, I have one of my members who went out every day for a year at high noon and took a picture to document the lack of boating activity at high noon in one particular cove where he was trying to get a permit. And he was told that this was, in fact, a really highly used area. But he was able to hand in 365 photographs showing a lack of boating activity, which was marvelous. I don't think it won the day. Is there any way to defend yourself against this spurious charges that come up in so often in these hearings?
Yeah, I mean, I think documentation and again, building that administrative record is the best you could do. And it'll depend on, what the agency or regulator is and whether or not that wins the day. But importantly, that will also set you up if you need to do a potential appeal or challenge. So for example, two areas where this has come up a lot in my practices, if wherever you choose to do something, all of a sudden it's their favorite fishing spot when it comes to recreational or commercial fishing. And then you'll move it, and then somebody else say that's my favorite spot. And so the best way to deal with that is try to coalesce whatever objective data you can. So for example, in some cases we've used transponder data, fish landing data, etc., which doesn't tell a complete picture. But that in combination with some firsthand testimony like you're talking about, I think has been helpful. They'll still continue to say it, but at least it gives objective criteria and data for the regulators to consider. The same thing has happened when we've been negotiating with tribal interests, where a tribal member will say, that's my favorite spot to do subsistence gathering or hunting or whatever it may be in conformity with their tribal treaty rights. And, we'll be very respectful in all of these circumstances. You don't want to come outright and say, point a finger and say you're a liar, because that doesn't seem to be productive. But providing objective data that says, actually, there haven't been any fish tickets reported there, or there hasn't been any observed activity on those hunting grounds. And usually we try to be pretty delicate about it. We say, listen, well, okay, we're not out there all the time, but we're out there quite a bit at a time. And so they might be there when we're not there, but here's all the data we have that shows that we're not seeing them and they're not reporting things. And that, I think, tells at least a good picture to the extent you can to the regulators and agencies involved. But that obviously won't stop them from weaving some stories.
Thank you.
Just a very quick follow-up to that, Robert, because I agree 100% with what Bob said. And we actually, in the state of Maine, witnesses at hearings are sworn in. And my question to you is, and to my knowledge, nobody's ever been prosecuted for perjury. Is that, I mean, can you even do that? Or does the state have to do that? Or is it just a complete and utter waste of time?
So two things about that. First, usually perjury is a criminal charge in most circumstances. And so you can't bring it, as far as I know, in every state, you can't bring it personally by the company. It would have to be, you would have to alert the appropriate, first the administrative panel or the judge that the witness has perjured themselves, and then try to seek enforcement of that by, depending on the circumstances, a DA or whoever might be prosecuting on the other side or the regulator, certainly. But what you could also do in that case is, if there has been clear perjury, especially to preserve your right to appeal that, notify the regulatory agency, especially when there's been somebody that's been sworn in, that they provided false testimony that's demonstrably false, and that's, grounds to basically both exclude and strike their testimony from the record. And if they're persuaded by that testimony, to basically call for a new hearing. And so even if that is denied at the time, that will set up a grounds where you might be able to appeal that determination if you're actually able to prove that, that testimony is demonstrably false.
All right, I think we have time for one more question, if anyone has one. Just to follow up, Robert, is that done at the hearing?
Again, yes. I mean, the local rules, and depending on the type of hearing, it may vary, but usually, yes, you want to preserve that record at the time it occurs. And so, don't jump up and say liar, liar, but, when it's appropriate to do so, certainly after they've ended their testimony, alert the regulator of that and make sure that that's on the record, particularly where, you've got a circumstance where somebody actually is being sworn in, and there is a record of it, to preserve your right to appeal that issue. Some localities and state laws will allow you to raise that issue after the fact, but in many, if you don't raise it during the hearing itself, you may waive your right to do so. So to be on the safe side, I'd recommend when it's appropriate to do so during the proceeding, make sure that that's on the record.
Okay, great. All right, well, I'd say we'll close it out with that one. I'm going to drop my email here in the chat really quick. Just before we wrap up, just, please consider NAA a resource. We talked about site selection, permitting guidance. There's a lot of stuff out there, interactive GIS maps and tools that can really help you do a lot of the upfront legwork. And please consider NAA a resource. Reach out to us anytime. We can put you in touch with the right folks and hopefully avoid some pain and hurdles down the road. But Robert, this is just a fantastic presentation and discussion. And I'm excited to say this is our first ever part 1, part 2. So look for more information about the upcoming one. We'll schedule it soon and get you back on here to talk about litigation. And with that, we'll next month, we're going to actually, I guess, continue our marine aquaculture theme. Kip Tyler with the Environmental Protection Agency is going to be on, giving us an overview of the guidelines for permitting marine aquaculture farms. And with that, I really hope everyone has a great Friday and the rest of your weekend. And thanks again, Robert.
Thank you.
Bye, everyone.